When a judge delivers a ruling and the required actions are successfully carried out, the book officially closes on that specific case. In December 2025, Honorable Mr. Justice Adama Hama Isa Dashin delivered one of these final rulings at the Federal High Court sitting in Lokoja. He ordered the registration of the National Democratic Congress, or NDC, as a political party. The sole defendant in this matter was the Independent National Electoral Commission. They complied with the judicial order immediately, and the NDC was officially registered. At this exact moment, the machinery of the law had worked exactly as designed. A ruling was made, an order was obeyed, and the matter is definitively settled. But 5 months later, in May 2026, an association called the Peace Movement Party, a group that wasn't even involved in the original case, filed an application demanding that the December ruling be thrown out. Justice Dashin heard the application and agreed. He reversed his own decision, effectively tearing up a judgment that had already been executed. A trial judge pulling back an entirely finished case months after the fact breaks the basic mechanics of the legal system. To understand why this ruling causes such a massive structural crisis, we have to look at the math involved in reopening a case. Nigerian civil procedure provides a way for someone showing up late to contest a default judgment, but they have to follow a very specific, strict sequence of legal steps. This double-barreled hurdle relies on conjunctive law, clearing conditions in a fixed order. First, Prayer 1 requires proving a substantial reason for delay to secure an extension of time. Only then can you approach Prayer 2, presenting a valid defense on the merits. Because these requirements are conjunctive, you cannot simply pick the one you prefer. If you fail to explain your delay at the first gate, the court is legally prohibited from even looking at your arguments at the second. When the Peace Movement Party filed their late application in May 2026, they correctly listed both of these steps, Prayer 1 for the time extension and Prayer 2 to set aside the judgment. Justice Dashin listed both prayers in his ruling. Yet, when executing the steps, he skipped right over the required time extension and went straight to killing the original judgment. The court bypassed the required legal gatekeeper. There was zero judicial interrogation into why this group waited 5 months to attack a ruling that the Electoral Commission had already complied with. The Supreme Court of Nigeria has spent decades solidifying this exact process. Rulings in cases like Williams v. Hope Rising explicitly mandate that an applicant must show good reasons for the default before disclosing a defense. Ignoring this prerequisite is a fatal blow to the validity of the judge's new ruling. By setting aside his own substantive decision without forcing the applicant to clear the statutory hurdles, the federal high court judge essentially acted as an appellate court over his own trial. This violates the legal concept of functus officio. When a judge finalizes a case on its merits, their authority over that specific dispute is exhausted. They no longer have the power to change their mind. This is a strict constitutional boundary. Under Section 241, the power to hear appeals from the federal high court flows strictly upward, belonging exclusively to the Court of Appeal. A high court judge possesses zero constitutional mandate to sit in judgment over their own executed decisions. If the Peace Movement Party had a legitimate grievance with the original December registration of the NDC, their required legal route was a trip to the Court of Appeal. When lower courts ignore this route, everyday citizens lose the ability to trust the legal system. If a final, executed order can simply be undone by the same judge months later, no litigant can ever truly rely on their court victories. The stability of a nation's jurisprudence relies on finality. Decisions like this act as a sledgehammer to that finality, fracturing the bedrock of public trust. This judicial disappearing act abandons the established math of the courtroom. It trades guaranteed structural law for absolute unpredictability.